My name's Lee Perlman. I'm a consumer bankruptcy attorney. I've been practicing bankruptcy law since 1994. I've helped thousands of people in the state of New Jersey deal with foreclosures, wage garnishments, bank levies, and give them breathing room and a fresh start. It's important to understand what a foreclosure means. Typically, in our state of New Jersey, if you fall behind on your mortgage, usually at about 2 to 3 months, you're in a situation where you have a pre-foreclosure status. So I want to talk a little bit about the foreclosure timeline so people understand what that means. You get an intent to foreclose, then once you get an intent to foreclose, it's typically an informational letter from your mortgage company, whether it's Chase, Ceteris, PHH, Mr. Cooper. You get a letter that says, Mr. Smith, you've fallen behind a couple months. At that point, you're not in foreclosure, you're in pre-foreclosure. So New Jersey is one of the states that we call a notice state, which means that you're going to receive notices along the way before the continuum or the train that gets to the station that's going to be the sheriff's sale. So the beginning of the process is the intent to foreclose. The end of the process is the sheriff's sale. A consumer, borrower, homeowner will receive notices all along the way. For someone to stand up and say they never got notice of their foreclosure is patently absurd. You're going to get a pre-foreclosure notice at 2 to 3 months. What to do? Treat that notice with importance. Understand what's going on. That's an opportunity to say, hey, maybe I want to speak to an attorney. Maybe I want to understand what my loss mitigation options are, which include loan modification. Maybe the mortgage company has decided to send me a notice of pre-foreclosure and I want to request a forbearance, or I want to request a deferral of payments. We're going to talk about what those terms mean. But it's important to understand when you get that pre-foreclosure notice, act on it. Do something. Do not throw that notice in the trash. Do not put that in your recycling bin. Understand it's an opportunity to use it as an informational exercise to dig down and find out what your rights are and what you can do to help yourself right away. So you get the pre-foreclosure notice, try to figure out what you want to do next. After that, you can be served with a complaint for foreclosure. It's formal. It's typically going to be served by the sheriff. It's going to be from a law firm. It's going to have a caption in the top left-hand corner, which is a law firm who's representing the lender. At that point, you have 35 days to respond to the foreclosure notice. You need to seek an attorney and you need to file an answer. An answer is your response to the court with regard to what your defenses are. What are typical defenses to a foreclosure? Let's say that you've fallen behind on payments and they've misapplied payments. They've used the wrong interest rate. They've sued the wrong party. You're in a loan modification stage and your foreclosure is still moving forward. There are rules with respect to receiving a foreclosure complaint if indeed you have filed an application for a loan modification and all that paperwork is in and considered. So we want to be mindful of that. If for some reason you don't answer the foreclosure notice, or if you fail to see an attorney, after that there's going to be a foreclosure judgment. After that they're going to get a default. That's another 30 days. And then a default judgment. So when we talk about a foreclosure timeline, it's typically a continuum. My firm has a foreclosure chart that we're happy to send you that talks about the beginning, the foreclosure, which is the instituting of the intent to foreclose, all the way up to a sheriff's sale. I like to say historically that timeline takes, usually about 6 months. Obviously it's slowed down now with respect to COVID. You can request a COVID forbearance at this juncture, where you can call your mortgage company and ask for a pause in your mortgage payments. A couple tips. Remember that if you're requesting a COVID forbearance, you want that to be in writing. The mortgage company should memorialize after you've spoken to them what you've agreed to. Does the forbearance include payments? Which payments does it include? When does it expire? How are the payments to be handled when the forbearance is over? Are they going to be put at the end of the loan? Or if the forbearance is 60, 90, 30 days, at the expiration of that forbearance, are you going to be required to make those payments? All that information needs to be memorialized in writing. If you don't understand what the deal is, you should speak to an attorney so they can help you negotiate terms. Very important. Loan modification. You can request a loan modification if you've fallen behind. What's a loan modification? A loan modification, typically you're seeking to have the interest rate lowered, you're seeking to have missed payments put at the end of the loan, or in some cases you are requesting what's called a principal forgiveness or a forgive and forget. So for example, if your home is worth $100,000 and you owe $200,000 to the mortgage company, you may be seeking a loan modification for any one of those criteria. If you get a loan modification package into your lender 37 days prior to the scheduling of a sheriff's sale, the mortgage company must stop the foreclosure process under the 37-day rule and begin to consider your application in a meaningful way. Consider means the mortgage company must communicate to you in writing. Is the loan modification accepted? Is it rejected? Or do they need more information? If the mortgage company continues with the foreclosure and your package has been deemed complete, there could be a violation of the loss mitigation rules and could also be a defense to your foreclosure. Now, in an unlikely event that you've received a sheriff's sale notice, you need to understand that that's a very significant event. Typically, in New Jersey, you have 2 opportunities for a sheriff's sale adjournment. They used to be at 2-week cycles, now they've gone to a month. So each side, both the mortgage company and the borrower, okay, what we call the mortgagor, the borrower, they have an opportunity to get an adjournment at 2-month cycle periods. Same with the mortgage company. After that, you have to go to the court to seek approval. So that's changed. So if you receive a foreclosure notice, understand that you want to treat that notice very seriously. You need to understand when to defend the foreclosure. We talked a little bit about that. Remember, defenses could include missed payments that may not be applied, interest rates that aren't being considered, loan modification applications that are not being recognized by the mortgage company. What's not a defense to foreclosure? I'll tell you what's an unrecognized defense to a foreclosure. I can't afford to pay. You know, they've come after you, they said, I've lost my job and I don't have the ability to pay. The ability not to pay the mortgage company is not a defense to a foreclosure. It could be the basis to seek a loan modification. It could be the basis to seek a forbearance or a deferral, but it's not a legally recognized defense. If you answer your foreclosure complaint saying you lost your job and you don't have the ability to pay, the court is likely to go ahead and seek to dismiss your answer so that the mortgage company's attorneys can proceed with foreclosure.